Let's say that the judge does determine that this person is eligible for bail. What are some of the factors that they need to consider? So the law goes on. So that was just the introductory part of the statute. The things that Kyle's attorneys are going to need to be looking at are included further down the statute in a different part of the law. And here's where the law, I think, is really on Kyle's side in a lot of different ways. We can look at the text and we can start to sort of see which ones are in favor and which ones are not. So what I've done here is I've actually copied and pasted the statute from the Wisconsin statutes and put it here in a slide, and I've broken it down into bullet points or numbers so that you can see specifically some of the things that the judges are going to be looking for when they're determining whether or not to release Kyle. All right, so let's go through them. Now, the stuff in green is stuff that I think is sort of favorable to Kyle. The stuff in the red is not so good for him, and the stuff in the yellow is sort of open to interpretation. So let's read through the statute. So let's say the judge says this is a case where Kyle can get bail. We're going to let him out of custody. The court says that if it is imposed, or the statute says, if it is imposed, the bond amount shall only be in the amount found necessary to assure the appearance of the defendant. So once again, necessary to ensure, or here to assure the appearance of the defendant in court. Is a $2 million bond necessary to make sure that Kyle appears in court? If they made it a $500 bond so he could get out, would he still come to court? So it should only be the amount that's necessary to ensure future appearance. That's what this statute says. Something that's way too big or way too overbroad doesn't meet those elements of the statute. It becomes more punitive rather than it is helping to ensure that the criminal process is moving forward smoothly. Okay, think about that. If the amount of money is so high, it can be punitive. Now, Kyle has not actually been convicted of anything yet. He's been charged with crimes, but he's innocent until proven guilty. He deserves his day in court. But if a judge posts a bond that is $2 million and there's no way that he can hit that amount, then essentially he's being deprived of certain freedoms, whether you agree with it or not. He's being denied certain freedoms and he hasn't been convicted of a crime. So the judge needs to do a very careful consideration on all of these factors. We're taking somebody who is innocent and we're depriving them of their liberty. So what are the factors that are going into play, and what are Rittenhouse's attorneys doing to make the appropriate arguments to help ensure that his release is secured? So let's go back to the statutes. What they're going to be looking at here is they're saying that the conditions of release may be imposed for the purpose of protecting members of the community. We've already spoken about that. We are also talking about preventing seriously bodily harm. We're talking about preventing the intimidation of witnesses. And so the court goes on, and the statute goes on, and it says that these are the reasonable conditions of release are, right? The first one, which is sort of up in the air for Kyle, is whether the person has the ability to even give bail. So does Kyle have the funds to get out of custody? Can he post a $2 million bond? I have seen no evidence that he comes from a rich family, or that they have the means to even come close to that. I'm not an expert on the actual mechanics of bail and bond in Wisconsin, but I have heard from other attorneys who are familiar with it that if Kyle if it's a $2 million bond, he's got to post the full amount of that $2 million. Does his family have that? I highly doubt it. Is the general public going to be willing or able to help him generate that amount of money? I think potentially. I mean, that is a massive sum of money. We have some of the lawyers for Kyle Rittenhouse, I think, doing some fundraising and engaging in some campaigns to help assist with that. But I've also seen some other headlines throughout the news showing that some of these actual fundraising, crowdsourcing programs and entities and business entities like GoFundMe and some of these other ones, I don't know about them specifically, but they're actually not taking money for this type of a case. And so they're not allowing their platforms to be used to help fundraise for Kyle Rittenhouse, which is, of course, sounds like a double standard to me. I think there's a lot of politics going on in that decision, not necessarily, fairness or equality or any of those things. All right, so let's go back to the statutes. The second factor that the judge needs to consider in determining whether Kyle should be released is the nature, number, and the gravity of the potential of the offenses and the potential penalty the defendant faces. Right? This one is obviously not good for Kyle. The reason is pretty obvious, right? The nature of the offense, they're murder charges. Intentional homicide. He showed up. He intended to kill these people. And there's no self-defense claim. That's going to be the government's position when they're discussing this factor. The self-defense can come into that equation, into that analysis, but still the severity, the gravity of the offense is very high. It's the highest thing that we have, right? And other people are dead. The penalty that Kyle faces are also very severe, very high, right? He can go to prison for life if he's convicted on all of these charges. And then the other bad red factor here is whether the alleged acts were violent in nature. That's sort of debatable. You could look up that statute and decide, what is violence versus self-defense. Violence to me has sort of the connotation that you are doing something that is inappropriate. You're being violent when it's not justified. Violence is unjustifiable. Whereas if you're defending yourself, somebody else was engaging in violence, not you. You were defending yourself. They were the ones who were being violent. You were just being a good person, protecting your life and your property. So I'm not real sure, how that factor goes in, but I think many people would just say, hey, he fired a gun and other people are dead. That is close enough to violence that factor may not weigh in his favor. But I think there's strong arguments that go the other way. Basically everything else, in my opinion, is good for Kyle's case. And again, these are all directly from the Wisconsin statutes. The next we have number 4, the defendant's prior record of criminal convictions and delinquency adjudications, if any. The only thing that we are talking about here, Kyle has some traffic tickets that also happened, I think, in Wisconsin. Very minor. One was going 20 to 24 over the posted speed limit, civil ticket, not a criminal charge. To my knowledge, I don't know of any other criminal history that he has whatsoever. And so that factor weighs in his favor, that the judge can look at that and say, this guy's never been in trouble before. And why, if he's never been in trouble before, then how can he be a danger to the community? This is one aberration. This is not a pattern of somebody who's willfully breaking the law day in and day out. Factor number 5, the character, health, and reputation of the defendant. And, this is an interesting one, right? Because Kyle is super young. Character, health, residence, and reputation of the defendant. He's very young. He basically has no reputation. We know very little about him other than the fact that he's 17. I understand he's a lifeguard. He was there trying to, remove some graffiti and protect some property. And he's got a lot of pro-police Facebook posts and things like that. But other than that, we don't know much about the guy, and nor should we. He's 17. His residence is in a different state, which is somewhat of a concern, but I think we can cure that issue if we sort of craft his release conditions in a different way. The character and the strength of the evidence is number 6. The character and strength of the evidence, which has been presented to the judge. We did a deep dive on this one, right? We went through the case line by line in the probable cause statement. We went through the video. We did an audio video frame by frame analysis on this channel, and it all looks like it favors Kyle pretty substantially. So I think the character and the strength of the evidence weigh majorly in his favor. The number 8, we've got whether the defendant, number 7, whether the defendant is on probation, extended supervision, or parole. Kyle has not been in trouble at all, ever. So he's not on probation. He doesn't have any other pending cases, no other pending cases here. He hasn't been bound over for trial after a preliminary examination. He's got nothing going on. He hasn't had a past forfeited bail or violated a condition of release. He wasn't a fugitive from justice at the time of the release. And there's just no evidence that he's a threat to the community at all. So all of these different factors, protecting the community, preventing the intimidation of witnesses, assuring he can show back up in court, I think they all weigh in his favor. Now, they're also in factor number 11. These are not numbered. I just numbered them out for the ease of dissecting this statute. If you look at the statute itself, it's actually just a big, messy word salad paragraph. So broke it down for you here. The policy against unnecessary detention of the defendant's pending trial. So, the idea is that he has not had his day in court, and we want to get him out of custody so that we can, allow him to live his life. He's innocent until proven guilty. Those are some of the factors that I think the court by law, by statute, is supposed to consider.